Hello, this is Amarjot Singh. I'm ICCRC consultant based in Edmonton. And I'm back with another video about residency obligation. As you see on the screen, Section 28 of Immigration Refugee Protection Act lays out conditions where you must be willing to live here for a certain number of years in Canada to maintain your PR status. It's called residency obligation. It says on the screen 730 days in 5 years. So if you land today for the next 5 years, you must plan to be here in Canada for 2 years, and then you can renew your PR card, or if you're eligible, you can apply for citizenship after the third year nowadays. There are some situations by which your residency obligation requirement of 2 years is waived. Those conditions are listed on the screen. So if you are employed on a full-time basis by a Canadian business and then they make you, work overseas, like you're working on China or something for a Canadian corporation, your days are not deducted. Look at number 2. If you are accompanying a Canadian citizen who's a spouse or common law partner, and if it's a child, their parent, in that case also, so let's take an example of, so let's say my wife is a citizen and I'm a PR card holder, and we both of us are living overseas. Since I'm accompanying my wife and she is a Canadian citizen, my days are maintained. That means my residency obligation continues. All right, number 3, so accompanying a permanent resident who's a spouse and who's employed full-time basis. So that means if husband and wife, both of them are PR, but let's say my wife is employed overseas, she's working for a Canadian company, but both of us are living overseas. In that case also residency obligation is maintained. So those are the 3 conditions. Those days are not deducted. In other circumstances, your days will be deducted. So for example, you come here and then suddenly you decide, oh look, I have some education degree to complete maybe in that country, and I should go back, and I've got some cases where people were studying medical degree, and because it's a long degree, it takes about 5-6 years, and they want to return to their home country and say, oh, let's get your medical degree done, and in that time of studies, you actually ignore, knowingly or unknowingly, that you have to spend 2 years in Canada and a maximum of 3 years overseas, and sometimes you prolong that stay overseas, and as a result, you will lose the status when you come back here. If your PR card is still intact, that means still unexpired, you come back here and the CBSA at the airport asks you, check your days, how many days you are gone, and if they find that you have exceeded the time that you have stayed overseas, and also in other case where it is unlikely that you will be able to maintain those days by living here now. Sometimes people say, naive things like, oh, I just came here for a week and then I'm going to pack up my things and go back again, continue my studies, whatever. You will lose the status. They will write an inadmissibility report, refer you to the Immigration Refugee Board, and then the member of IRB will decide. So it's very important that you pay attention to your dates. I prefer actually when people come here, they have the passport, they have the entry exit stamp, they should make a table on when did they come, and if they are going on for a brief vacation, maybe for 1 month or so or something, they should make a list of all those dates of entry and exit matching with the stamps on the passport, because whenever you have to renew your PR card, those dates will be required. You have to write those dates and you have to produce those records with a boarding pass or stamps on the passport or some other verifiable proof that you actually stayed here, you were in Canada for those dates. What I want to talk to you today is also, let me just scroll the screen, is there is a definition of accompanying. I don't want to dwell on accompanying definition here. Sometimes what happens is when you are applying, let's say you are overseas and then you have either your PR card is expired, or for some reason you want to, or maybe it's lost, or your PR card is lost even though it's valid, and then you are applying for a travel document, and now you have to list in detail all the dates where you were living in Canada, and then you have to produce all the documents to show that you actually were in Canada. Sometimes what happens is if you have exceeded the time which was allowed for you to live overseas, they give you what is called a discretionary relief in residency. This is about appeals though, but those factors are still in calculation where the visa officer overseas is looking at how to give you a travel document or to resuscitate your status back to normal permanent residence. I wanted to show you some humanitarian and compassionate factors which should be mentioned if you know that you have exceeded the days allowed, and now you are asking the visa officer to use HNC factors, which is humanitarian and compassionate factors, in allowing you to retain the permanent resident status. There are some factors. HNC is a complex area of law, and in basically, in plain English, humanitarian compassionate denotes that somebody, the visa officer, of course, the visa officer must have the factors which they feel that they have sympathy to your situation. I mean, you justify, based on the circumstances, you justify that your status must be retained, even though you do not have the necessary days. But I want to show you some factors here which are used in appeal as well, but you can pretty much also ensure that when you are applying for the travel document overseas, you can use that as well. Or if you're just straight a few weeks or maybe even few months beyond the allowed time, you can use these factors to appeal to. When I say appeal, means not like legal appeal, to influence the visa officer's decision by documenting and quoting these factors. So let's take a look at these factors, and I read on the screen: the significance of the factor considered whether equitable relief should be granted naturally varies from case to case, of course. So take a look here. This is a non-exhaustive list of factors considered, and take a look. So the first one is the extent of non-compliance. I mean, if I'm in non-compliant for a few days, it's very different from compliance if I'm gone for 5 years. There are some people, I'm shocked, and they had the PR card, but they went back to their old job and say, hey, I even forgot that I had a PR card. So suddenly after 5 years, say, hey, I did have a PR card. How can I go back? And now they're applying for travel document, or now you're applying. It's not going to happen. But look at the example of if the extent of non-compliance is few days or few months or 6 months or many years, and that is what they look at in HNC also. That's the criteria number one, as you see on the screen. Look at the reasons for departure from Canada. Sometimes people will just move to their home country even though they have a PR card. Because my grandparents were there, or my parents were living there. They were lonely. They wanted me to come and live with them or something. So I said, oh, what the heck? I'm going to go back and live with them, something. So they have to look at, the visa officers to look at what is the reason of departure. I mean, why did you go there? Did some business take you there, or some family connection took you there, or maybe some Canadian company had perhaps given you a job from here and you were working overseas, and after the job finished, you forgot to return, or there was some whatever the reason, what actually took you there. So that's an important criteria by which they can decide whether they can give you HNC relief as well. Look at number 3. Reasons for, number 3 is right here. Reasons for continued or lengthy stay abroad. Some people, maybe because of legal reasons or some other reason, maybe they are in jail, overseas for some reason. I don't know why would they be in jail. I hope there's not a big criminal case, but maybe they have lost their passport, or maybe they have, maybe due to the medical circumstances. What was the reason why they had to stay abroad? And that's what, I think that those reasons will determine if somebody can take a compassionate view of your reason or not. I mean, if it looks like it was definitely beyond your control, I think then you have a positive influence on that outcome as well. Look at number 4, whether attempts to return to Canada were made at the first opportunity. Sometimes, I hear some cases where children, dependent children, they accompanied their parents, and they were put into school overseas, and after they turned 18, after 19 or 20 or whatever, after when they became adult, did they actually made an attempt to return to Canada? If they had a chance, if they had an opportunity, whether they actually tried on their own to come to Canada or not, or they just stayed as if nothing matters. So that's That's also important criteria. Degree of establishment in Canada. If I've been gone out of Canada for many years, but I still have my wife and children, and I'm paying tax. Even though I'm living overseas, I'm paying taxes. I have property, and I'm continuing some kind of business or something. So if I'm already established in Canada, even though I'm physically overseas, that is a very important factor for the visa officers to consider whether that PR should be retained or not. Family ties. Look at this one. Family ties to Canada, whether they are sponsored. Think of this. For example, if I've been living overseas and my wife is in Canada, and maybe she's a PR and she's a citizen, and if I lose the PR status and if I'm back to my home country, can I be sponsored again? Can I be sponsored by the wife again as a PR status? That's an important factor. Or vice versa. If I'm if the whole family is overseas and for some reason I lose the PR status, how can I, if I get the PR status again, can I sponsor my wife and children again? So that's a quite a influential criteria to understand how does my personal status affects the whole family. That's something that they have to look whether I can help them to sponsor them back to Canada or not. So that's a criteria right there. Look at this one: hardship and dislocation at cost to appellant. The family, well, yes, of course, it's very obvious. If the whole family loses the PR and they are overseas, perhaps maybe there's a medical problem, or there's a what is the hardship? What is it? Maybe I'm going to a country, maybe there's already a crime infested or uninhabitable, or maybe there's already, can you imagine if I was deported back to, if I lose the status and deported back to a country where there's already like an earthquake or some other, some other disastrous situation there. So they have to assess what is the dislocation and hardship caused by it. Best interest of child, which you already know, how the children affected. This is a very interesting subtopic in Immigration Refugee Protection Act. It's called BIOC, best interest of the child. If you type BIOC on the immigration website, you can see a detailed and exhaustive list of what are the things that they see in the factors that will affect the child. Whether the child will be suffering any I'm sure they will be suffering something, but there's a certain standard that they maintain. If the children are affected, they will say yes. If they are not affected as much, they will probably say no, maybe it's not that much. So I urge you to type best interest of child on the immigration website and take a look at the exhaustive factors on best interest of child in all applications. Actually, in all HNC applications, BIOC is a big factor. Whether or not there are unique and special circumstances that merit, of course, as you can see. So I'll show you some. There's a reference on best interest of child. Yeah, take a look at. There's a reference to the best interest of child. In this case, Andrew Daniel, the member found that the best interest of mentally handicapped children would be served by allowing the parent who assisted a community care where the children were living treatment in Canada. This is an interesting case. So you'll get a factor of how really they look at the best interest of child. So what I wanted to emphasize is, for a variety of reasons, it is imperative for you to maintain your permanent residence days in Canada. If you have to leave, and you cannot come back, these are the factors, as you see on the screen, are something that you must keep in mind whenever you are applying again to come back to Canada. So if you have these factors, detail, and specifically mentioned step by step, I think you have a better chance of getting your PR status back. Otherwise, you'll have to fight for an appeal though. Now, even in the appeal, if you have clearly lost all the days that were required to be here, these are the factors nonetheless will be also addressed at the time of appeal. So these are the factors, something I think every PR in Canada, if they are looking to travel many times back and forth from Canada to other countries, I think they should they should be careful of what they are trying to do, and what factors they can develop on one of these, so that they have a good chance of getting the status back. So that's all I had to say about this. I hope you keep your status, and if you have any problem, these are rest of the documents is about travel document, which I will say a PR document. There are some case studies also. By the way, you can go to the Immigration Refugee Board website, and if you want to type this, and you will be able to see all this text also. But I think just remember these things. If you have to take something from this video, these are the things that you should keep in mind, all right here on the screen. All right. Thank you very much for the time. I'll see you next time in a new video. Thank you.